now offered a lesser include of manslaughter in the second degree. I mean, what does that tell you about the state and what they think their case is, right? That they have now started to add additional charges.
Same objection, Your Honor.
They're not adding charges, counsel.
You're right. They've requested a lesser included. That's exactly what's going on.
Well, I will say this. The state's opinion, just like defense counsel's opinion, are not evidence.
So they've now brought a lesser charge. A lesser included charge.
They haven't newly brought this. It is a charge that is included within the ambit of the original charge.
And what does that require? It requires that you fail again to be aware of a substantial risk of death, that it may occur, and that it constitutes a gross deviation from the standard of care that a reasonable person would exercise. Very similar, but that you fail to be aware. So I want you to think about these allegations, manslaughter allegations against our client. Because this is not just an accusation against our client. It's also an accusation against Officer Ford. It's not an accusation against Officer Ford because it implies that Officer Ford sat back
No, I'm going to object to this.
and watched.
Hold on. I'll continue, counsel.
Thank you. It implies that Officer Ford sat back and watched our client commit manslaughter and did nothing. Because we know he's next to our client throughout the entirety of the incident other than when he goes to go get fired. So think about that for a second. Take a step back. You've heard from Officer Ford. He's a local kid. Went to Stadium High School, graduated in 2010. He grew up in Tacoma. He was a park ranger in the summers. He worked with Tacoma Metro Services with the development disabilities, with people with development disabilities. He took them hiking and painting. And he also knew the Ellis family. He knew Ellis's mother, Marcia. She was his high school counselor, a mentor to him, and they stayed in touch after high school as well. And he testified in this case. And he was Officer Rankin's partner for 3 months. And in that 3 months, he said that their communication was always really good. Now, the instructions are that you are the judges of the sole credibility of the witnesses. Now, when you saw Officer Ford testify, you never saw any text messages about, I can't wait to take the stand, or I'm going to be lying to shut you all down. And you also saw how Miss Eakes cross-examined him. She says that this isn't an attack on police. And what was his testimony? He said that if he saw anything inappropriate or excessive from Officer Rankin, he would have intervened. And that is reasonable doubt. Because he would have intervened if he saw something wrong. He's not going to stand back and watch his partner commit manslaughter in front of him. And you know, you have to think about how the state has been trying this case. And this is a slide from the state's closing argument to you. And in there, Miss Eakes, put a question and an answer. And the question was, in that in-between time, between the first recovery position and being prone and the second recovery position, did Timmy Rankin get on his back or anywhere on his body? And the answer they put was, I believe so. Now, we've been doing this for almost 12 weeks at this point. And the state knows that I have the same transcripts, that I've ordered many of the same transcripts of them that they have. And what they do is they conveniently leave out the next question and answer. Because if you look at what's actually said in that in-between time, right, that's what's included in the state's closing. And what is the next question? And what is the next answer? Did you see any pressure applied at all on Mr. Ellis by Timmy Rankin? Nothing that I would consider excessive. That's not what they put in their PowerPoint. And that's how this case is being tried. And that's a scary proposition, because the prosecutor has a duty to the defense as well, and the defendant, I should say, to ensure that they receive a fair trial. They have to present all the facts and allow you all to make decisions. An approach like this completely undermines our system. That's how innocent people get convicted of something they didn't do, especially our underprivileged individuals. Victory at the expense of full truth and a fair trial. You know, they do this throughout the case. They take Timmy's statement as well, the statement he gave to detectives, and they slice it and dice it, and they manipulate it. For instance, when Mr. Ellis said, "I can't breathe," in that calm fashion, as he testified to, and that was odd to him, or weird, I think is the word that he said. Same as Officer Ford, that he said, "If you can talk to me, you can breathe," and and that's where they leave it, right? But that's not the full sentence. That's not the full context. And he said, "And if you stop struggling with us, I can relieve some of the pressure." And we're talking about a moment in time where there's the 4 officers struggling with this individual, and he's dragging them across the pavement. And what does he do? He goes right away to positioning himself somewhere else. And what does Mr. Ellis do? He goes right trying to get back up. And we're talking a brief moment in time until other officers can arrive. And we slice it and dice it and dissect it. But when we look at the CAD report and we look at what time period we're talking about, and we look at how Officer Rankin is modulating his actions, that's not how it's actually done, by the way the state is presenting it. And Jared talked about, Mr. Osser talked about, he's the short guy over there, he talked about some of the things that the state hasn't presented. The medical records, right? The EKG data that they never gave to their experts. The 2015 and 2019 incidents, right? That they never presented that. They knew about those incidents. They know that it's relevant. No, they're not incidents that just don't involve anything similar. They're incidents that involve methamphetamine in Mr. Ellis. They knew about the state toxicologist Asa Lewis. They sat in the interviews with them while he said if an individual had these levels and hadn't been using for a period of time, it would be lethal. They sat there in those interviews. He barely ever testifies for the defense. He testified 500 sometimes, a handful of times for the defense, and we're calling him in this case. What does that say to you but reasonable doubt about how this case is being done? You know, they say that we're putting Manuel Ellis on trial. I completely disagree. We're not putting Manuel Ellis on trial. We're putting methamphetamine on trial. We all know, and we heard actually in jury selection, about how methamphetamine is devastating our community and how drugs are devastating our community. But instead, they have this myopic view of it, and they want to say, we're trying to attack Ellis. That's not true. We've all said it's tragic that he died. No one has ever taken his name in vain. So I want to talk about the state's case against our client, Officer Rankin, because it's a very different case than the case against Officer Collins and Officer Burbank. And what we have here are all the witnesses, at least what I could remember, maybe I missed one, but all the witnesses that the state called in their case. And the red ones are witnesses that were never on scene at any point or saw our client at all leading up to the point that fire was there. And we know that there's two witnesses, Miss Malang, formerly known as Miss White, and Lieutenant Wilson. You know, we sat through this trial in the first couple of weeks. I sat back. And the state called Miss McDowell, they called Mr. Lowry, they called Mr. Cowden, and none of those individuals have anything to say about Officer Rankin, because Officer Rankin wasn't on scene. And you may have remembered my cross-examination was pretty much, okay, our client wasn't there during any portion of this. Quite boring. But the message is sent, right? That they've never called a single eyewitness that has anything bad to say about our client, because there's none. And they sat there and they went through video after video and audio tapes after audio tapes. But there's one video of our client, and that was taken by Miss Malang. And if you remember this video, it's Exhibit 443 and Exhibit 22. And you heard for many days of testimony from Grant Fredericks. And Grant Fredericks seems to have an opinion about everything, right? What we see, what we hear. He says, well, the hand is over the throat at this point. Oh, he's not slipping off of him, or he's slipping off of him, or he's not pushing him. He also says, I don't hear anything in the audio about do it again, although he's gotten the Hallamore transcript and knows that's what Hallamore says it is. And he's got an opinion about everything. And the state has this video. But he doesn't have an opinion about this one. Because it doesn't fit within their case. You know, they also called an accident reconstructionist, Mr. Wells. I don't know if you remember that. And he specializes in reconstructing scenes and what you're able to see in certain photos or scenes that are particularly complicated. They spent thousands of dollars on him, but they didn't reconstruct this scene because it doesn't fit within the parameters of their narrative. Because what this video shows, and we asked Miss Malang about it, what this video shows, and we asked her, she said that it showed when she was looking out the window, and I don't know if you all remember those photos of her looking out the window, that that's where she took it. And she says that it shows them knelt down on the ground next to them, their knees are on the ground, and their hands out are holding them at that point. She also used the word doggy pile in there. And then when we asked her on follow-up, remember she said, oh, that was just a figure of speech. I'm talking about people standing around. I never thought this would ever be played in a courtroom. You know, from her point of view and what she sees, from that, if she saw someone on top of Mr. Ellis, she would have told us. And Officer Rankin also testified about that video and what he believes to be his positioning in it. That's the only witness that they called that had anything to do in terms of eyewitness testimony about our client. And in that moment, she sees him not kneeling on top of him. She doesn't see him doing anything inappropriate. The next witness that they called, Paramedic Wilson, and I find this photo actually a little bit amusing because it shows who's going through the EKG data, right? Throughout this trial, I nerd out on the EKG data. You know, the medical side is very interesting to me because it's good for our case, because the medical doesn't lie. The EKG data doesn't lie. And when Paramedic Wilson arrived on scene, he testified that he saw Ellis on his back slightly to his left, and he said it's referred to as the recovery position. That's two eyewitnesses. Both of them have seen our client with Mr. Ellis, and in both instances, he has him either on his side or he's kneeling down next to him, holding him with his hands. You know, Paramedic Wilson also talked about the fact that he had minimal respiratory drive when he arrived on scene. But he said that to an untrained eye, that would not be something you could pick up on. And we know that Officer Ford also thought that he was breathing up until fire arrived, just like Timmy Rankin. We also asked about first aid with with Lieutenant Wilson. And we said, would you have expected them to be doing any type of first aid leading up to that? Any type of CPR? He says, no. I mean, he had a pulse for up to 5.5 minutes when he arrived on scene. So he's not expecting them to be doing CPR. They're not paramedics. You know, Timmy talked about what type of first aid he has within his vehicle, and I think he called it a Walmart first aid kit. I mean, that's what our government gives these officers in that point, right? A Walmart first aid kit. They're not paramedics. They're not first aid. And he wouldn't have expected them to be rendering any type of first aid prior to his arrival. I call this slide the Sherlock Holmes slide, because this is where we try and figure out certain time periods. And so we know based on the video, and I've done this with you all as well, we know based on the video where I filled out different time frames on here with Tim, right? And we went through that. I think you all remember that. And so we know, based on the videos that do see Timmy arrive, that he and Ford arrived sometime around here. And it's a couple seconds after the CAD actually has them arriving, because they call out arriving, and then they get there. And we know other officers are starting to arrive here based on the video. I think the CAD has them a couple seconds earlier, but they're starting, you can see them on the video, starting to arrive with those loud sirens coming. And we know based on the CAD that they say one detained and slow incoming at this point. And Timmy thinks at that point that that's when they actually get him in the hobbles and put him in the recovery position. And we know they call for an ambulance to back up fire, that fire had been called at this point at 23:25:48. Right? A little over a minute after Timmy and Ford arrive. And then we have the white video. We know that in that point of time that Ellis is in the recovery position. At the very least, Timmy is not on top of him at that point. And we know when the white video ends, and then we know when fire arrives on scene. And that makes perfect sense as well, right? Because they're seeing fire from about 7 or 8 blocks away and flipping him over. So that completely corroborates what they're saying, that he is in the recovery position long before fire is there. And so the question is, like, what's going on in this 6-minute and 36-second period of time? Because we know he's in the recovery position here, and we know he's in the recovery position here, and we know at one point he starts thrashing around within this period of time, and he's, as Ford described it, he's briefly put onto his stomach and then put right back into the recovery position thereafter. Well, we know that there are also 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 officers that are arriving on scene in between this time period. Across 4 different agencies, as Jared told you. That the state, Ms. Eakes, Ms. Nicolavo, and Kent Liu have interviewed every single one of those officers. The state doesn't call a single one of them. I mean, prosecutors rely on officer testimony all the time. Can you imagine? You have 13 eyewitnesses to a case, and the state, the prosecutor, doesn't call a single one of them. They hold the burden. They know that the testimony is unfavorable to them, and they don't call them. That is 14 different reasons for you all to have reasonable doubt in this case. Because if those 14 officers across 4 different departments are going to sit back and watch someone commit manslaughter, that is absurd. That is an absurd allegation. And they won't say that because it didn't happen. Now, this again represents the tunnel vision and failing to present to you all the facts. So who is the witness that they call to talk about use of force? Well, we know, Jack Ryan. Jack Ryan is their one witness that talks about what Timmy did that was wrong in terms of use of force. He's not an eyewitness. They flew him over here from Rhode Island, and he talks in broad strokes about training. He never shows you a single document about any training materials. It's all smoke and mirrors. You know, he understands that Sergeant Lim is on scene, and he says he's been teaching for decades, or that this is positional asphyxia has been taught for decades. But then on cross-examination, if you remember, there was an article that he wrote in September of 2020, right after this incident. And in that, he says that there are a number of trainers that misunderstand the issues related to positional asphyxia, and there is at least one trainer from the state of Washington that says it's debunked. We know that Mr. Ryan was part of that Julia Sherwin email that introduced Dr. Wolgener and the other state's experts. We also know that there was another use of force expert by the name of Sue Peters. That she was used to support the probable cause statement in this case, and the state never called her to the stand. That is reasonable doubt. You know, one of the things from the get-go of Jack Ryan's testimony is I remember that they were asking him about how long Timmy Rankin had been a police officer, and he said 2018. And I was sitting there thinking, he knows that's not true. So the first thing I had to do, right, was get up there and show him the actual records. Because he was hired in 2018. But as he's told you, you have to go to BLEA, to the Basic Law Enforcement Academy, before you're ever an officer. And that didn't occur, he didn't graduate until 2019. You know, he's trying to manipulate things to try and make it seem as if Timmy had been an officer for a longer period of time, when it's just an objective fact. He can't tell you how long or how much pressure Officer Rankin put on him. And he talks in absolutes. You'd never do this. You'd never do that. But we know that that's not police work. You can't talk in absolutes because it's such a dynamic and dangerous job. Mr. Nielsen, Chris Nielsen, our expert, been hired by the state 3 different times. You know all this. He was hired by Miss Nicolavo, and he talks about control superiority. The principle is there. He talks about the Tacoma policy manual, and he demonstrated on me the cuffing situation. So, expert Jack Ryan talked about training. We know that he had all the BLEA training, but he never presents a single piece of training material to you. I mean, think about that. You don't think that these officers received handouts or that there's PowerPoints to support what he's saying? But he doesn't present a single one of them. So let's talk about the training that they actually get. So let's talk about Officer Ford and the training that he got. Because the state asked him on cross-examination, Miss East asked him, she said, and you're trained on positional asphyxia, are you not? And his answer was, what he recalls from that section of training is, for lack of better words, that people dogpile on a suspect and remain in that position for an extended period of time is when it becomes an issue. And if you remember that after he said that, the state cut right to Miss Malang's video where she uses the word dogpile, even though we all know that she has just testified that she's like, well, I know that they're not dogpiled on them, I'm just using it as a figure of speech. But they're manipulating it in that way. And that's a scary way to prosecute a case. They also asked him about air hunger, this idea of air hunger, a term that these officers have never actually heard. And Officer Ford testified to that as well on cross-examination. And you also heard from our client, Officer Timothy Rankin. He testified to you and he demonstrated to you what he did and why he did it in that moment and the control tactics that he took with Mr. Ellis. And I query you this. If there is a substantial risk of death, why on earth would a demonstration like that be allowed? I mean, if you are undertaking actions that are a substantial risk of death, there is no way that that would be allowed in this courtroom. And when he was asked about positional asphyxia, he said the same thing Officer Ford said, that it's multiple officers piling on top. And we know that's not what took place. We know that Officer Collins is holding onto his legs, Officer Ford is holding onto his legs, and Timmy is the one putting pressure on his torso until other officers get there. He's immediately put into hobbles and put in the recovery position. And we know Ellis continues to struggle at that point. He continues to make growling noises while Officer Ford sits with him and says, calm down, breathe, relax, fire's coming. Now, you have to use your common sense here. People get arrested all the time. These type of demonstrations happen all the time. Thomas Clark. Thomas Clark, as Jared talked about, even acknowledged that positional asphyxia is a disputed term within the medical community. Well, if it's a disputed term within the medical community that somehow completely undermines the state's theory that they are going to say, well, these officers should know about. I mean, the medical professionals are even saying that it's not, that there's just as many studies on either side, he said. And then there was an interesting moment with Dr. Clark that he had, and I feel like a couple of you picked up on it, where he said he was talking about, well, I'm not actually sure that prone restraint actually contributes to any type of hypoxia, because they do that for COVID patients in the hospital. They put them prone so to help them breathe. And that's what it was almost like he had this epiphany while he was on the stand. So the spit hood. Another officer put the spit hood on. It's significant to Dr. Clark. And there's no dispute about these facts. Officer Rankin's not trained on it. He's never used it. He doesn't even carry a spit hood in his car. He never requested it. It was requested by another officer, and he did not assist in placing it on him. You know, his recollection of it is really only as good. We're trying to ask him to remember what happened 3 years ago in a traumatic incident involving this multiple officers, somewhat chaotic. And we know also that this happens in March, right? March 2020. Let's think about what was going on in March 2020. A week later, we have the pandemic, and we all shut down. Everything shuts down. And actually, Marcia mentioned it when she was on the stand. She said that when she was having that last conversation with her son, that he mentioned, Mom, what's going on with this whole COVID thing? But at the end of the day, you're to focus on Officer Rankin's actions. He's not an accomplice to anyone. And if this is a significant factor to Dr. Clark, that's reasonable doubt. The hobble. Again, he's never been trained on a hobble. He doesn't carry a hobble. He's never used a hobble. He didn't request it. And he did not assist in placing it on. What he said is that when he was helping restrain Ellis, that other officers placed the hobble on him. So to try and place blame on Officer Rankin for something he's not trained on, when other superior officers are requesting it, and you're focusing on his actions and his intent. I mean, he has been an officer for 14 months at that point. And Dr. Veal, the state's pulmonologist. You know, what was interesting about Dr. Veal is that he acknowledged that he doesn't know specifics of when Mr. Ellis was put in the recovery position and when he wasn't. And he says that he acknowledges that he was put in the recovery position twice, but he can't tell how long. And he also said that if Mr. Ellis had said in a calm voice that he couldn't breathe, that it wouldn't have been all that concerning to him at that point. And Officer Ford and Officer Rankin both testified that that's how they heard it in that moment. And Miss Eakes, you know, she's playing these videotapes where, I mean, you guys are going to have to judge whether you hear some of that or not. But after the fact, to try and play something and say, is this when you hear it? Is this when you hear it? I mean, that's not a fair exercise. And the last thing I want to talk about in terms of recklessness and criminal negligence are the 2015 and 2019 incidents. And the exhibit for the 2019 video, the release conditions is that exhibit, and the court date that was upcoming for Mr. Ellis. He had a trial date that was upcoming. And so you heard from Deputies Pressel and Deputies Moss about the 2015 incident, and that's the domestic violence incident where they have Mr. Ellis in the back of the patrol car, and he has the syringe with methamphetamine in his pocket. And, you know, they talked about the difficulty in trying to restrain him in that moment, that there was 3 officers trying to hold him down, and that he's kicking and bucking, and that at one point, Deputy Moss said that, you know, he was trying to bite her, so she had to kneel on his head at one point. I mean, that's why you don't talk about absolutes like Jack Ryan is talking about in that moment. And, you know, they eventually have to hobble him in that situation as well. And then they also call for fire because he has abrasions as well from hitting his face on the ground during that moment. And we know that that incident involved methamphetamine. And I ask you this. When you heard testimony from Pressel and Moss, how many times, well, they testified that they held Ellis until fire could arrive. Did you ever hear them testify about putting Mr. Ellis in the recovery position? Did they ever testify about taking his pulse, checking him for injuries, telling him to stay calm, to breathe? So when you're talking about a gross deviation from the conduct a reasonable person would do, I mean, look at those officers in that scenario and look at Officer Rankin, what he's doing at 14 months, that he's putting in the recovery position, that he's checking him for injuries, that he's taking his pulse. All evidence of care, all things that weren't done in those other incidents. And I'm not casting blame on them, but I'm just saying that if this is the standard, if we're looking at what a reasonable person would do, a gross deviation, so 2019, right? We've seen the video, and we know what happens. And we know that Ellis gets up, they're making commands to him. You hear him kind of cry out in the same way that he's cried out in videos of in our case as well. You also see him putting his hands out a couple of times like this. And then he gets up and runs at the officers, and they have to tase him. They tase him once, he immediately gets to his feet, or almost gets to his feet, and they have to tase him a second time. And again, multiple officers have to restrain him. And they have to call fire. And they hold him in place, in position, until fire gets there. Again, I ask you, did you hear any testimony about any of those officers checking his pulse, checking him for injuries, taking out the taser probes, putting him in the recovery position? I mean, those incidents highlight the fact that our client is caring for Mr. Ellis. He has no intent to harm him and has no degree of disregard that he's going to cause the substantial risk of death, or that it's a gross deviation from the conduct that a reasonable person would do. I mean, look at those prior incidents and compare it to what Officer Rankin did in this scenario. I want to talk about causation. And again, you have to compare Officer Rankin's instructions to Officer Burbank and Officer Collins because he's not an accomplice, so you have to focus on his actions. So that the defendant caused his death. It's not the defendant and an accomplice. And actually, that's a very big issue for the case. Because they have to prove that the defendant's acts or omissions were a proximate cause of the resulting death, right? And what does proximate cause mean? We've gone through this a couple times, so I might go a bit quick, but I ask you to take your time and look at this stuff. The term proximate cause means a cause which in direct sequence, unbroken by any new independent cause, produces the death, and without which death would not have happened. There can be more than one proximate cause, but without which death would not have happened. And Jared's talked about this as well. But the fact that the court has determined, and you must accept as true, that Timothy Rankin and any other non-defendant was not an accomplice is hugely significant. Because what the state says, and this is one of their slides in their closing argument, is that the fight is what killed him. Well, our client wasn't part of the fight. And I don't think that that's true either. But that they can't differentiate between what killed him and what didn't kill him, right? And you heard it from every single expert about how complicated this case was. And so I want to go through a couple of the medical records with you because I want to show you some of the things and give you a background of Mr. Ellis leading into this incident and some of the complications he had. Because when we talked with the medical experts, and I'm going to go through this fairly quickly, but I'll try and remind you of what some of the exhibits are so that you can look through it. And I urge you to look through all the exhibits as well. Because when you look through all the exhibits, one thing you're going to see as well is there's not a single training material about positional asphyxia that was ever given to these individuals either. So the first one, this is 981. Well, it stems from 981 as well. 981 is the Good Samaritan hospital documents. So this came from Jacob Assett. And one of the things as well about Jacob Assett, and I don't know if you remember this, but Jacob Assett was the death investigator for the medical examiner's office. And Miss Nicolava was the one who did direct examination of him. And she had him read every single portion of his report, but she never had him read any of the prior diagnoses that he had, right? I mean, Manuel Ellis is 33 years old, and he has even Dr. Mitchell said, he is not a healthy individual. And we know that even at 33 years old, he has an enlarged heart, right? And he's already in heart failure at the time, and we'll talk about that in a little bit. But let's look through some of the records. I'm going to go quick on this because it's a bit boring. But, so we know that Mr. Ellis says that he's been using drugs since 2009, and he says that he'll pretty much use whatever he gets his hands on. Heroin, cocaine, he smokes methamphetamine. I mean, he doesn't have a healthy lifestyle. He has a terrible drug addiction. It's really sad. And we know that in 2015, he's going to the hospital, to the ER, on 7 different occasions. I mean, he is 28 years old. He's going to the ER on 28 different occasions. And you heard from Dr. Stankus that we don't have all of the medical records here. And we tried to get as many as we could to try and figure out what's going on with this individual. But one of the things he says in this report as well is he says that the AH, which I think is reasonably interpreted as auditory hallucinations, he says that they are praising him. He states that the AH are not bothersome, but they do increase when he uses methamphetamine, right? And so we know that that's occurring even back in 2015. We also know that in 2017, he starts talking about his health. He says that he's concerned about his health, it's not improving, he's feeling weak and having difficulty breathing, and he expressed a genuine uncertainty and fear regarding his health and his future. And this is what he's disclosing to his mental health providers as well. And then we know that he says in 2017, I can hardly breathe sometimes, my chest hurts like hell. We know that in 2019, he fills out heart condition, medical history that impacts current functioning. I could die, I almost died twice. I mean, we heard that he had a code STEMI a while back that was eventually called off from a code STEMI. But we know that he's having issues with his heart leading up to this. He's got pericarditis. He's got endocarditis as well. And we know that he's continuing to abuse methamphetamine and drugs, and his addiction is getting the better of him. So this is the Greater Lakes, and if you remember Rochelle Pastellari's, butchering her name, but she took the stand and she talked about Manuel not feeling well and displaying labored breathing, right? And she kind of told us what was going on. I think she even showed us that he was breathing like this. And this is 3 months prior to our incident. And if you remember that I was asking Dr. Mitchell about this as well. And I said, well, he's having breathing issues here. And he said, well, he didn't die in this instance, did he? And I've thought about that comment. And he's right, he didn't die there. But this is during a time period that he's sober. I mean, how much methamphetamine did he have in his system when he's meeting with his mental health counselor and having breathing issues and displaying labored breathing? And we know as well, and I'm going to discuss this also, we know that he is in heart failure at the time of this incident. It's the hemosiderin macrophages. It's when you have your lungs filling up with blood because your pump is failing. And so this is significant. He is getting sicker and sicker. This is the Pierce County Alliance report, and he talks about he's talking about the 2019 incident here. And he's talking about the fact that methamphetamine exacerbates his mental health issues, and then he recently had a 5-day binge that led to a full psychosis. So he's talking about him being psychotic when he has that unfortunate 2019 incident, and that's significant as well because it's a 5-day binge, right? And then we know in this case that he's clean. So he's been clean. He's been doing really good. He's on the right track. Because a couple days prior to our incident, it says he's been clean since December. And he's getting UAs as well. So it's not like he's on a bender up until the time that he has 2,400 nanograms of methamphetamine in his system and a sick heart. He's been clean. He's been doing really good. And Monet talked about the fact that she believed that her brother didn't have a drug addiction issue, but he had a mental health issue. And based on my review of the records, I couldn't agree more. Because if you look at the records, and you look at the Greater Lakes records, and you see when he's discharged from mental health treatment, in 2019, 2 months prior to the incident with the A&W, he gets discharged. He stops going to mental health treatment. And when he stops going to mental health treatment, he starts to self-medicate. He starts to self-medicate at that point. And then what happens leading up to our incident? He stops going to mental health treatment in November. 3 months later, he has this incident. I mean, that's the cycle. It's terrible. And here's the toxicology report, right? 2,400 nanograms. And Asa Lewis testified to this as well. Oh, forgot one thing. So this is significant as well, because we know in the medical records that Seroquel has been working for him. Because he has these mental health issues. And Seroquel is something that's been working for him. But you see, he doesn't have those in his system at the time. He's off his medication. And that's when he falls prey to his addiction issues. And so, I think that's significant because it just shows you that Monet is right. I mean, it's a mental health issue that leads to this terrible drug addiction issue. And we know that the state had this, and they never called the toxicologist. And you also heard from Cedric Armstrong, Jared talked about this as well, about the bad meth going around. I've never heard of good meth, but there was bad meth going around, and that it was causing some type of psychosis. We also know that he's clean and sober until he leaves at 10:30 that night, and he leaves with Mendel Everson. And Mendel Everson is kind of this character that where is he? He never even comes back to the house. In fact, he calls up Cedric and says, "Sell all my stuff. I'm not even coming back." He knows something has gone wrong. Monet and Marcia both had no reason to believe as well that he was using that day they had spoken with him. And then we have the autopsy report. Jared went through this. Again, this is the beauty of going last. I didn't know what he was going to go through with you. I have it up as well. So an argument could be made that the extremely high methamphetamine concentration should be the primary factor. I mean, that is a significant statement. I mean, they're all significant statements. And if you think about the state's closing argument, right, they showed you the autopsy report, but they didn't show you the opinion report. All they did was flash hypoxia and homicide. They just flashed that portion in front of you. When this is the actual opinion of Dr. Clark, when he never had any of the EKG data. And he says that he still had sinus cardiac rhythm, right? His opinion is premised upon the fact, what is Ellis's heart doing at that point? I mean, it's the root of his opinion, because otherwise it doesn't reveal any anatomic finding of death, right? There's no petechial hemorrhaging in his eyes showing that he was asphyxiated, which sometimes you get when you're asphyxiated. You know, there's nothing else that he could point at, that he said he could point at, that would cause death. But, you know, if you think about that, it's a strange statement to make, because there are. And he's found death multiple times based on these methamphetamine levels alone, based on those cardiac issues alone. But instead, in this case, before he retires, and you saw the way that he was upset about certain things, in this case, he rules it a homicide, right? Which, again, he acknowledges is not a crime, but he has 2,400 nanograms of methamphetamine in his system and an enlarged heart that could have caused death by itself. One significant thing here as well is that he said that it's unlikely that death would have occurred due to the physical restraint alone without those contributing conditions, right? So one of the things I asked Dr. Clark to do was, remember my masterpiece that I tried to fill out, and I've looked like an idiot in front of you guys a couple times, and I tried to fill out what he was relying upon. I better go get it. Is it here, Miss Warren? Oh. There it is. Right? Handcuffed and hobbled, prone, meth, heart, spit hood. That's what he said. Officer Rankin didn't have anything to do with that, right? He's injected into the scene at that point. He's already handcuffed. Other officers asked for hobbles. He's already proned out at that point. He's got meth in his system. Nothing Officer Rankin can do about that. His heart, and he didn't do the spit hood, never trained on the spit hood, anything like that. And so what I asked him then was, he even said that he established the most likely cause and manner of death based on the information I had at the time, and those were the things that were listed on your sheet. This is the sheet, I would say. Okay, I asked, and that did not include any amount of weight on Mr. Ellis's back. He said no, it didn't. So what he's determined is that Mr. Ellis is going to die regardless of the AGs telling him that there was weight put on Mr. Ellis's back. He made that determination of a homicide, right? And that he was going to die in that moment, never knowing that information. And when the state has to prove that this but for, right, that without which death would not have occurred, well, we know death would have occurred because he determined death was going to occur. And he certainly can't say beyond a reasonable doubt anything like that. And when I asked him as well about this case, and he says he would agree with me wholeheartedly that this is a complex case in terms of medical and pathological issues. He said wholeheartedly. He said opinions could differ. That's what he said. Reasonable doubt. So I want to talk about, right, the rhythm that he relied upon. The rhythm he relied upon is that he said, number one, he did not have a pulse when emergency medical staff arrived, which is, you know, the state in their closing argument, they put up this slide with Dr. W, Dr. Dan, I also call him Dr. Cut and Paste, that he didn't have a pulse. He goes, well, if he's going to die of respiratory issues, it's no pulse, or if he's going to die of cardiac issues, no pulse, and then stops breathing. Well, they assumed that he didn't have a pulse the whole time. I mean, you remember my interaction with him where I said, I mean, how on earth could you assume he didn't have a pulse when EMS arrived next to him and don't do CPR for 5 minutes? He said, well, I'm not casting any blame on anyone. I mean, it was an absurd proposition to begin with, and we know that all he does is pretty much take his opinions from other reports. You know, I totally reject the contention and then it's word for word the same throughout the report. So Dr. Clark's opinions were based on the fact that he had normal sinus rhythm on the EKG, and he didn't have a pulse. And we already know that he did have a pulse, right? And what do we know about normal sinus rhythm? Well, the EKG data. I may be boring you with the EKG data, but it's super important in this case. You know, every one of their experts opined on this case without ever seeing the EKG data. And when Dr. Clark wrote his report, he didn't have it. Dr. Dan didn't have it. They never gave it to him. And that is very important, right? Because when I asked Dr. Clark, right, he had been hired by the state now, and he testified that he was apprehensive at first about getting hired by the state. Initially, he said, no, you need to go find someone else. And then he said, well, they convinced me. So then he ended up getting hired. And then they put a gag order on him so they couldn't talk to anyone. And then, when I asked him about the EKG data, when he was on the stand, I couldn't believe it when he said it. I still haven't received it. He's testifying in this case, and the Attorney General's office has still never given him the EKG data. That is hugely problematic, because his whole theory in this case rested upon the fact that it was normal sinus rhythm and no pulse, right? So what does Dr. Wohlgenertner do? And I talked about the fact that the state, during their direct examination, I know a lot of you have been taking copious notes, and I really appreciate that. And I think that you should look back on your notes. But during Dr. Wohlgenertner, the state cardiologist, they never showed him the EKG data during any portion of his direct examination. During any portion of it. Instead, he sat here and he did this symphony thing, remember? And then I did this stupid trumpet. Because it doesn't make any sense. It wasn't a symphony. The trumpet was going off. The drums are going off. That's not an organized rhythm. That's not PEA. It's not sinus rhythm, right? It's not normal sinus rhythm. And Dr. W, he has to admit to it, right? Because I asked him, I said, the initial EKG, right, the electrocardiogram, does not show normal sinus rhythm. He says, correct. It doesn't show sinus rhythm either. Correct. Right? And look back at what the autopsy report says. Sinus cardiac rhythm. That he still had sinus cardiac rhythm. He didn't. He had an arrhythmia during the time period, and Dr. Stankus talked to you about that. And paramedic Wilson, again, me, with the EKG data, going through it with him. The state never showed it to him on direct examination. And part of his testimony is important as well, because when he fills out that pre-hospital care report, he doesn't have the benefit of looking at the full-fledged EKG data. You all will actually have it. If you have any issues downloading anything like that, please let us know as well, or let Ms. Winnie know. But when he had interviewed with the Attorney General's office with Dr. Clark there, right, and he talked about the oddity of that interview, where he felt like Dr. Clark was trying to pressure him into saying things that would support his opinion. And they never showed him the EKG data during that interview, but he doesn't have the benefit of going through that EKG data when he writes his pre-hospital care report. All he said he's looking at this tiny little screen on the LifePak 15, which is the monitor, the defibrillator that they're using. It's this tiny screen that he can look at. But, you know, he's now had the opportunity to look through it again. But the whole time he's maintained that he had a pulse up until the point that we know, I think it's like 40-50, 37-40-50 or something like that. But, you know, he talks about the EKG data, and he gave this great example about the electrical circuits of a house, right? The upstairs and talking down to the downstairs, that the atrial wants to fire 1,000,000 times, but it's not firing. But they're giving him oxygen, and he's not getting better. And he said this is a perfusion issue, right? That the rhythm is going, it's super irregular. It's going high, it's going low, then it goes high again. I mean, it's showing you that his heart is sick, that his pump is broken, he's not oxygenating the rest of his body, and his heart is giving out at that point. And Dr. Clark tries to say, well, if you die of methamphetamine, you just pretty much drop dead. I mean, that's not how this works. Dr. Stankus talked about that as well. That's not how this works. When you have an individual, each individual comes with their own problems, right? Each individual has their own pump, their own heart. And Manuel Ellis comes to this scenario with a pump that's broken and massive amounts of methamphetamine on board, and asking his heart to work 1,000,000 times harder than it can. We also talked about the fact that methamphetamine also restricts blood flow, right? So vasoconstriction, that restricts the blood vessels from pumping blood as well. So it's this perfect storm. You have a situation where you have methamphetamine on board, causing your heart to go rapid. You have a heart that can't keep up because it's already in heart failure and has a cardiomyopathy and doesn't pump properly. And then the meth also causes your vessels, vasoconstriction, to be smaller and not be able to pump blood. I mean, it's a very dangerous scenario. What I'll say to you is that, when something in the medical community like this, when something's true in terms of the EKG, you can't change those facts. It doesn't change. And that's something that you obviously see the state shying away from in this case. And ask yourself why. Because it doesn't support their theory. When I asked paramedic Wilson, who'd been doing this job for 20 years as a paramedic in emergency rooms, resuscitated many, many people, I asked him, given Mr. Ellis's presentation, and you're giving him oxygen, if this was a respiratory issue, would you have expected him to get better? And he says, correct. Given his age, I would have expected him to respond positively to that treatment. The patient failed to respond positively to that and continued to deteriorate. So we're forced to act, we're forced to do CPR, and now we're in this position. Because if the issue was oxygen, he was getting oxygen, he's not getting better. And the reason I say that these facts don't lie, right? The medicine doesn't lie, is because we had Dr. Stankus as well. And Dr. Stankus, again, during her direct examination that I did, she took you through the atrial flutter with variable conduction, right? And she took you through the EKG. She is a local emergency room physician. She's worked in hospitals at Tacoma General that, Ellis even went to. She's dealt with methamphetamine addiction as well. The state tries to go after her because she was a cop 20 years ago, and her daughter is a police officer, and they said, well, you're pro-police, right? But that's not what her position was. You remember what she said in response to that? I mean, you think she's going to take the stand and just lie about that stuff and walk through the EKG data with you? What does that say? Because when they asked her, you're pro-cop, what was her response? She's mainly a defense attorney, or a defense expert. She's usually testifying against police officers, for the defense. And she said, I would be the first person that if there was something going amiss, that she would be the first person to call it out. And Mr. Liu tried to just say, well, you're pro-cop, you're pro-cop. No, read the full answer that she gave. Because don't manipulate what she told you. The stark difference between Dr. Stankus and the doctors that they called is the facts that she relies upon. Because you're really only as good as the facts that are presented to you. And here we know that the facts that she relied upon, she never relied upon the fact that Mr. Ellis was pulseless, like their experts did, when EMS first arrived. She never relied upon the fact that he was in PEA, when they first arrived, or that he had normal sinus rhythm. She relied upon the actual EKG data and the actual facts of this case. She said that this is a sick heart. She would be very concerned if she saw a rhythm like this. And she said, and she was entirely consistent with what Lieutenant Wilson was testifying to as well. So, heart failure, hemosiderin macrophages. The interesting part about this as well is that, Dr. Mitchell is the one who did the hemosiderin. They do iron stains to look at hemosiderin levels to see if you have hemosiderin macrophages, right? He's the one who did the iron stains when he came in and consulted on this case. Did you ever hear him testify about it? You never heard him testify about the hemosiderin macrophages. And I knew that he did it, right? I knew that he had those, and I was interested to see what he was going to say about it. But I just sat back there, and if he's not going to say anything about it, I'm not going to address it with him either. I'm going to address it with Dr. Clark. So Dr. Clark got up there, and think about that for a second. He does this, it's a significant finding, and he never testifies about it because it doesn't fit their narrative. It's something they don't like that he did, that he had those iron stains done, and they're like, well, not going to talk about that. Well, Dr. Clark did. Hemosiderin macrophages, and this is me asking him questions. If I understand it correctly, that's when when you have a dilated heart and it leads to some degree of heart failure. He said yes. And it means that the heart is not pumping blood adequately. He said yes. I said, typically when the heart would clear out blood from the capillaries in the lungs, it doesn't do so, and the blood just kind of sits in your lungs. And he said, that's right. Yes. And I asked him about what would be a common symptom, right? And he said, I asked him, a common symptom would be that he's wheezing and shortness of breath. And he said as well that it would take a period of time for this to transpire, right? Weeks or months. It's not something that just happens on the day in question. To me, if you're looking at what's happening to Mr. Ellis in November, when he's wheezing at this mental health session 3 months earlier, I think he's already in trouble at that point, right? He's not, his heart has taken a beating over the years. This guy, Asa Lewis. Asa Lewis, the state toxicologist in this case. And Jared talked about the state toxicologist, and, he talked about lethal methamphetamine levels, and I've already talked about him a bit, so I'm going to cut straight to his testimony. He says that of the death cases that you've seen due to methamphetamine overdoses, 2,400 is actually the highest you have ever seen, correct? And he said, his answer was even better for us. He said, I would say that I've seen individuals that had lower doses, right? This is a toxic, lethal, it's a lethal in this situation amount of methamphetamine, given his abstinence and tolerance over time. Because we asked him the hypothetical. It's interesting, right? We asked the hypothetical about facts that you all know. Because he's like, I don't know anything about Ellis. Well, you guys do, and that's why we're asking him this hypothetical. A person hadn't used meth for several months and then took 2,400 nanogram dose per milliliter. That would likely be a fatal outcome, correct? He says, correct. And then the state, right? The state presents in their closing argument. They say, well, he's seen plenty of people with 2,400 nanograms, right? And that he's seen people driving around with that amount. Well, what was his actual testimony, right? We asked him about that. We said, in those instances where you've seen people driving around with 2,400 nanograms, right? You've seen that, correct? He says, in those cases, based on your professional opinion, it would be unlikely that those people had been abstinent from using methamphetamine for a period of time, correct? He goes, correct. Again, we're talking about tolerance. So someone with a dose similar to that, I would expect that the person had been using fairly regularly. So that's his testimony. He does see people with those levels, but those are people that are continuing to use. Not on the right track for 2 months, maybe not taking their mental health, issues, or not going to mental health counseling or their mental health prescriptions, and then this happens. So let's compare Manuel Ellis's methamphetamine levels. We have what Asa talked about, which is the therapeutic level, which is 50 nanograms, he said, at the high end. The lethal level at 1,000, and every single one of the experts has talked about it being 1,000. And we have Robert Haig and Randy Steele. And those are the two autopsy reports that Jared talked about when when Dr. Clark said that they were due to methamphetamine. I mean, Manny's methamphetamine levels exceeds all of those. I would submit to you at this point, reasonable doubt is plastered all over this case. All over this case. Why don't they call these other officers? You know, why are they presenting facts in this way? But the law goes even further. There are defenses available. So it's a defense to the charge of manslaughter. The force used was lawful. Again, counsel's already gone through this with you, so I'll go quickly, but I want you to take your time during this and look at the instructions, right? The use of force upon another is lawful when necessarily used by a peace officer in the performance of a legal duty. And then a homicide is excusable when it's committed, right, by accident or misfortune and without any unlawful intent. And the state bears the burden of proving beyond a reasonable doubt that the use of force is not lawful and that there isn't an absence of an excuse when there's no unlawful intent. They bear the burden in those cases as well, in those defenses. They have to disprove that those defenses apply beyond a reasonable doubt. They also have to prove the charges beyond a reasonable doubt. And we'll talk about that standard in a second. Ms. Eakes never addressed it in her closing argument. She shies away from it.
Is this a time? Since we started earlier?
I'm almost done. But yeah,
I'm just thinking you got 10 minutes, that's what I'm thinking.
I can finish in 10 minutes, I think.
Right, so we'll take our break.
Okay.
All right, we'll be at recess for 15 minutes, ladies and gentlemen. Please do not discuss case among yourselves with anyone else.
defenses, the state has to prove beyond a reasonable doubt. So there's the two defenses, lawful force, right, as well as the defense of excusable homicide. And so when you talk about, the duties of an officer, the judges instructed you that a peace officer not only has a specific duty to enforce the law, but is also charged with the general duty and power to maintain the peace and quiet of the city, right? So that's their general duty. And then when you talk about what necessary is in this scenario, so if after notice of intent to arrest is a subject, the subject either flees or forcibly resists, a peace officer may use all necessary means to effect arrest. So I don't think there's any dispute about the fact that Mr. Ellis is forcibly resisting when our client arrives on scene, right? And what's important here is that necessary means under the circumstances as they reasonably appeared to the actor at the time, right? So to Officer Rankin at the time, not to Jack Ryan on the stand at that point, not to the state in cross-examination questions about, well, you could just pick him up and put him in the car, you could have done this or that, to the actor in that moment. And one of the things that we've talked about as well is that the calculus of reasonableness for a police officer has to take into account that a police officer are often forced to make split-second decisions that are tense, uncertain, rapidly evolving. And it's all, you have to take that all into account, right? When you're evaluating the circumstances here. Because not every shove or push that may later seem unnecessary in the peace of the judge's chambers, is actually unnecessary. Because I think the term was used, Monday morning quarterback, right? We ask a lot of officers in these scenarios, especially we've talked about the South End in that area and some of the difficulties there, just kind of the job that's inherent in there. So the analysis here is as they appear to Officer Rankin, and I'm going to use this term again, given his Rolodex of experiences, 14 months on the job, it's a standard that takes into account his experiences and what type of force that he's using. And he can use all means necessary, right? So if he's going to use force, is it a reasonable amount of force as opposed to no force at all? And so what is the level of force that he's using in this scenario, right? It's certainly not deadly force, and it's not assaultive force. Jack Ryan didn't testify to anything like that. It's control tactics. And we look at the police policy manual on this. You've seen this pyramid, I think it was a pyramid, where it has the differing levels of force that are allowable under the circumstances. And then when you have someone who's actively resisting, what are the different things that they can use? And not every force elective is allowable, right? Because there are things in there that said like a 40 millimeter soft bullet and a taser and strikes. I mean, some of those things, even if someone's actively resisting, are not reasonable in that scenario. But, I mean, what is the level of force that Officer Rankin is using in these scenarios, right? He's using control tactics, cuffing procedures. When the state calls into issue, they say, well, his knee is towards the middle of his back as opposed to up by his shoulder blades. Well, that is the dynamics of the job. It's not always Mark Conrad laying down on the ground just like this. This is a dynamic situation where Officer Rankin is injected into a scenario that he's never dealt with a hobbled individual in the first place, right? So it's a new scenario to him, and what is reasonable to him in that scenario? He doesn't punch him, he doesn't kick him, he doesn't kneel on his neck, he doesn't, he doesn't hit him in any way, right? He's trying to control him in those moments. And there are really only two uses of force that the state keeps taking issue with, which is the first time when there are four of them there and prior to other officers arriving, when he's trying to keep Ellis on the ground and he sees the gun magazine, he knows that this has been a very dangerous situation, he doesn't know what's actually transpiring, and he's trying to keep Ellis from getting up in that scenario. He's not trying to hurt him in any way, right? And so, and you saw with Jack Ryan, which I think was really a defining moment of his testimony, when I was going through this analysis with him of like, okay, well, let's be in this moment in time, right? Let's be there and try and run through the different scenarios. And I mentioned him, okay, and Officer Rankin sees the gun magazine on his back. And he responds, yes, and that later turned out to be Officer Burbanks. And remember I said back to him, I said, no, you're breaking your own rule, that's 20/20 hindsight, and that does not come into play here. You don't all of a sudden, because in that moment, Officer Rankin doesn't know that. He doesn't know what's going on in that scenario. You know, there's nothing that was said to him like, well, it's mine, don't worry about it. And then counsel wants to say, well, no one yelled out gun because he didn't see a gun, right? And so, you know, Jack Ryan's comment like that, and I called him out on it in the moment. I said, that's not fair. That's not how we do this analysis. And it's all necessary means, right?
Slow down just a bit.
Sorry. So, you know, what we know Ellis is dragging these guys across the street. There's no video of these moments, right? Because there's been that exhibit shown to you where we know that they have Vivint, then we have McDowell, we have Lowry, and then we have more Vivint video, and then there's the one Vivint clip that shows Officer Rankin arriving, and then there's nothing, and then there's the white video, and then there's nothing until you see a bunch of emergency vehicles there through Vivint. I think that's exhibit 443 is the full synced video. And then you see again a white video, and it's Officer Rankin trying to resuscitate and help with fire there, right? And so in this analysis, as it appeared to him, what is the amount of force? It's a low level of force. That's not an amount of force that is substantially likely to cause death, right? That is a bizarre proposition, especially when you put the individual in the recovery position twice. If it was substantially likely to cause death, Ford and those other officers would have said something. They all would have said something, said, hey, rookie, don't do that, right? And that's because it's a low level of force, and it's reasonably effective for the lawful purpose that he's trying to do, which is keep Ellis detained in that moment and figure out what's going on. Fire gets called within a minute. We know fire's coming. They're waiting around. It takes longer because we're at the outskirts of the city. And we know that Ellis is in the recovery position and those other aspects of it. You know, the state takes issue with the other use of force that he uses. I guess you can call it a use of force. But it's when Ellis starts thrashing around when he's in hobbles, right? And he starts thrashing around. He's on his shoulder. And, I mean, practice going on your shoulder and thrashing around. And, I mean, he really has to use force to keep him steady in that. So he's either holding, and I think Chris Nielsen discussed this pretty well. He's like, well, he's either going to hold him down there. That's force. He has to hold him in place. But Rankin was driving how he's like teetering, and so he's falling to his belly as well, or his stomach. And that the amount of force that he's using in that scenario is not significant because he doesn't need to use significant force because he's hobbled. And if he would have, someone, Ford, who's sitting right there with him, would have said something. So you have to take into account his training, right? Lack of training on hobbles, lack of training on spit hoods, lack of training on, you know, basic first aid. He has some military training. It's really about kind of plugging holes and, you know, stopping a wounded soldier from having, you know, blood injuries and stuff like that, trauma in that respect. And I think that if you look at this scenario as to what Officer Rankin did, you'll find that at the time as it appeared to him, it was reasonable for him to use force, and that the amount of force was reasonable to affect the purpose he had in that moment, which was to keep control of Mr. Ellis. The last thing I want to talk to you about is beyond a reasonable doubt. So this instruction is the cornerstone of our judicial system. Beyond a reasonable doubt. The defense has no burden of proving anything. We don't have to prove that a reasonable doubt exists. They're presumed innocent. Each officer sitting there is presumed innocent. So the allegation against them is just that. It's an allegation against them. And that presumption continues throughout the trial unless you deliberate and you find that it's been overcome by the evidence beyond a reasonable doubt. And that means a reason, right? A reasonable doubt is one for which a reason exists. It may arise from the evidence or the lack of evidence as well. And what I want to explain as well is the differing standards that are in the judicial system. You start at the bottom with reasonable suspicion, right? Specific and articulable facts or reasons. It's not based on a hunch or a guess. And then you go to probable cause, right? Facts and circumstances that lead an ordinary person to believe. That's how it's generally described. Then you go to preponderance, the civil standard, which applies, which is the great weight of the evidence, more likely than not. And then we go to clear and convincing evidence. Right? If the state, clear and convincing, the type of cases those apply to, clear and convincing, if the state wants to take your children away from you, they have to prove by clear and convincing evidence that you are not a fit parent. And even beyond that, the highest burden in the land is beyond a reasonable doubt. And this is the corner of our judicial system, because it's an awesome power that the state wields when they're accusing someone. It's not arbitrary. And I have a illustrative here that I think kind of describes words that, if they come to mind, that don't meet this standard, right? So if you are deliberating in this case and you think, well, I think maybe this is what happened, or by clear and convincing evidence, this is what I think is happening in this scenario, the decision is made. That is doubt. Though that's not the type of language that we use in the criminal justice system, right? Because that's how innocent people get convicted of something they didn't do. And you have to hold the state to their burden in this case. It is very important that we hold them to their burden, because if not now, then when? And I'll tell you this as kind of my closing remarks. Ms. Eakes is going to get up here on rebuttal, and I ask you to think about, what she's saying, because she holds the burden in this case, because they have the highest burden in the land to prove this case, she gets the last word. And I ask you to think critically about what she tells you, and because we don't get a chance to get back up here and say something else. I also ask that you hold each other accountable through this process, that you remind each other of what the law is, and have a discussion about what the facts are as well. And I think that there's let me move on. There's another instruction as well. It's instruction number 2. And it says, do not surrender your honest belief about the value of certain evidence, nor change your mind, and this is not word for word, but look at it, it's instruction 2, nor change your mind just to render a verdict, right? And so you must hold the state to their burden. Look at all the evidence in this case. I think that when you take the evidence that's been presented to you, actually I know, I have faith in this case, that if you take the evidence in this case and you apply it to the law, no outside influence, that doesn't apply. That's why we selected all you through this process for 3 months. And if you do that, and you look at Officer Rankin's actions, his evidence of care, of working with his partner, Officer Ford, in this moment, in a difficult moment, and you saw his emotion in there as well, And if you apply the facts, the actual facts that have been proven in this case, and I would say the defense has proven more facts than the state has in this matter. If you apply those facts to the law, there's only one result in this case, and that's a not guilty verdict for Officer Rankin. Because to say that he took actions that would create a substantial likelihood of death that is a gross deviation from the conduct a reasonable person would exhibit, that he failed to do that, that he knowingly disregarded that, right? Or that he's the cause of death in this case. That's not what the facts show us. It shows care, right? When Lieutenant Wilson was on the stand, there's something that he talked about which I thought was significant, right? He's not a paid expert. He doesn't know any of these guys. He said that the officers helped more than he ever would have expected. And that, remember the first reaction that Officer Rankin had when he got there? He said, "What can I do to help?" Wilson said that he wanted him out of the restraints. The first person he went to was Sergeant Lim to ask for permission. But in that scenario, he wanted to help. He cared. And I ask that you don't compound one tragedy with another by not holding the state to their burden, by not applying the law to the facts in this case in a way that is demanded for justice. And if you do that, again, I think that the result is clear. No doubt. It's not guilty in this case. Because reasonable doubt is plastered throughout this matter. They've not set forth one single eyewitness against our client that has said anything about him negative other than a paid expert. I thank you for your time over the last couple months, weeks. It's a very strange scenario to be here talking with you all and not being able to converse. It's weird. And again, I thank you for your time. It is an important task, and I wish you luck. Thank you.
As you heard from counsel, we're going to have rebuttal argument from the state, but I think we need a couple of minutes to do a little bit of a setup. So we're going to excuse you for a few more minutes. Please do not discuss the case. rebuttal closing argument on behalf of the plaintiff, the state of Washington, by Ms. Patricia Eakes. Thank you, Ms. Eakes.
So, you just heard, this is the rebuttal argument, and you've heard over 5 hours of arguments from the defense about the evidence in the case. And while the state disagrees with a lot of the facts, as the defense claims that they are, I'm not going to stand up here and spend 2 hours rebutting all of those different facts. As you know from the instructions, you are the people who need to decide what the facts are. And I encourage you to check your notes. I'm going to show you some things that I think cause you to think twice about some of the facts that have been put forward by the defense. But I'd also encourage you to read the instructions carefully. Again, those are the instructions that tell you what the law is, not what the defense says that the law is, but what the court says that the law is. So scrutinize carefully what they have to say. But I'm going to just kind of move through some things pretty quickly. Plus, it's the end of the day, and I know you all are tired and have been sitting here a long time. First of all, this is something, and these are just some of the facts that I think that you need to take a look at. And I'm just going to give you a few samplings of it. This is something that defense counsel said in closing argument. He said, "We know that Grant Fredericks reviewed the information from Mr. Liu about the traffic lights. And what did he say on cross-examination? That Mr. Cowden arrived at the time the officers took Mr. Ellis to the ground based on the reflection of his headlights in the car, on the vehicle. So we know he didn't see what he said he saw. Yet the state stood up in closing and said that they were all consistent. They all saw the same thing. Therefore, that's got to be true." So counsel represented to you that Mr. Fredericks had said that Mr. Cowden didn't arrive until after things were in progress and when Mr. Ellis was on the ground. So let's take a look at what Grant Fredericks actually said. And this is several slides, but it's important, so I'm going to kind of walk through it. Question that was being asked on cross-examination. "You did tell the AG's office when you thought he got there, didn't you?" He says, "Well, I know when he was there because we could see a reflection of the headlights off the police vehicle." So, and then he says, "Right, I'm going, let me finish, please." Grant Fredericks said, "You might remember this exchange because Mr. Fredericks was trying to make sure he was very careful. At the very beginning of the Vivint video, the side of the vehicle is illuminated by the headlights of Cowden." Yes. So there was at that point, but I can't say when he got there. Understood. So Mr. Fredericks is saying Mr. Cowden was already at the intersection when the Vivint video came on for the first time. But then he goes on. So he asked him, Mr. Oster asked again, "But you just told us you saw a reflection in the police vehicle that was consistent with him arriving in that time frame." And he corrected him again. "No, I did not say that." "When did he arrive then based on the reflection?" And Mr. Fredericks said, "So please listen to me very carefully because I'm very careful with my answers. What I said was, when the video started, his vehicle was there because the reflection of his headlights were on the police vehicle, not that's when he was arriving, just that he was there at that time." That's the testimony about it. He went on. He continued to try to get him to say something that he didn't say. "Well, you could see the reflection of his headlights on the vehicle." And he says again, "Not arriving. I didn't say," and counsel says, "I didn't say arriving, I said you could see it, right?" And Mr. Fredericks said, "I don't want to argue with you. I'm trying to be very clear. You did say it showed him arriving, and you said, I said that, and I didn't. So when the video starts, the headlights are already illuminated on the police vehicle. So I can't say when he arrived." This is critically important. They stood up here and told you that Grant Fredericks had said that Mr. Cowden wasn't there when this all started. And yet, you can see the testimony of Grant Fredericks. He absolutely said when the video came on, the very first video we have in this case from the Vivint, Mr. Cowden is already there because his headlights are already illuminated on the police vehicle. What other things did they say that you should question? How about this? Said that, talking about Miss McDowell, and you'll remember, he said, "Here's a video, take a look. You can tell that the light's green, Miss McDowell honks, she backs up, she sees them fighting, and then she starts recording." That's what happens. So he told you then, watching that video, and he played the video for you. He didn't play 443, which is the synced video, which I wondered at the time. He played an isolated video and said, "Watch this when she backs up. She's going to back up and she wants to pull around the car. She doesn't know anything's going on, and then she starts recording." So let's take a look and see. So this is the synced video from 443. And if you can start by just looking at this video, I want you to pay very close attention right here. This is Miss McDowell's car, okay? Watch for when it backs up and when you see it move back and you see the lights. If you can play it, please. Did you see it? Saw it just back up a second ago. Now if you can go and show the rest of 443. Stop! So when you see the lights, her tail lights flash like that, and defense counsel says that's her backing up, you can see on the synced video that Miss McDowell is already filming. She's already recording what she sees. So the representation that somehow she didn't see things initially, she's recording, and then you see her, and you see right after that she gets out of the car. So she's either putting the car in park, hitting the brake, so that she can get out of the car so she can start yelling, hey, stop that. That's exactly what you see on that video. That she was in there, she was already filming it, she had already seen it, consistent with what she said from the very beginning. What other things did defense counsel say? They talked about the fact that there's a transcript, and this is part of what they showed you, 18A, and he talked about the transcript that shows I can't breathe. And he said, oh, look at this. Their own expert didn't find that Mr. Ellis said that he can't breathe. But remember, the judge read you this instruction at the time that you got 18A. He said, this transcript is not evidence of itself. It is one interpretation offered to assist you in understanding and evaluating the audio evidence in this case. Keep in mind that the actual evidence is the audio recordings that are admitted into evidence. So it's not the transcript that was shown to you by counsel, which this is what he showed you from 18A and pointed out that there was nothing on here that said, I can't breathe. Well, let's listen to 659, which is the audio that's right here that's on this entry. So you can absolutely hear Mr. Ellis say, I can't breathe. Can you play it again? So still can't breathe. That's coming in over that dispatch. So again, representing to you that somehow Mr. Ellis didn't actually say those things. And the other thing that they said about with respect to this exhibit was that Mr. Ellis only said it 3 times as opposed to 5 times. But ask yourself, does that really matter? I mean, shouldn't 1 time have been enough for Mr. Ellis to say that he couldn't breathe? Shouldn't he only have had to say it 1 time for it to merit some sort of a response from the officers and for them to respond with something other than shut the fuck up, man, or respond with, hey, if you're talking, you can breathe just fine. So does it really matter how many times? But you can hear the evidence yourself, and you can listen to the evidence yourself. The other thing that defense has claimed is, well, the reason that they didn't hear it is because of auditory exclusion. And you heard defense counsel for Officer Collins claim that this was all about auditory exclusion, and that's why he couldn't hear what was being said. Well, when are those times said? When does Mr. Ellis say that he can't breathe? What the evidence is that he said it after, he said 4 times after Shad Hayes. And you'll recall that defense counsel talked about Mr. Hayes and how he was able to hear Mr. Hayes, right? Mr. Hayes says, calls out to them, and this is from 18A, and you can see it on 443, which is the exhibit, at 23:23:37. Hey, you guys need some help. And the officers respond, oh, we got somebody coming. Officer Burbank does. So at this point, and they both say in their statements, and defense counsel concedes, that Mr. Ellis is handcuffed at this point. He's fully handcuffed. And you can listen to their statements, and you can hear them talk about Mr. Hayes. And they both say that he's handcuffed at the point that they responded to Mr. Hayes.
This is a violation of Bruton for the 5th time.
Continue.
So in those statements, that's what they say, and defense counsel conceded that they're under arrest, or excuse me, that he's in handcuffs at that point. You remember that I showed this exhibit the other day of the times that Mr. Ellis said that he couldn't breathe. And what I added in here is the time when Shad Hayes said, called out to the officers. So at 23:23:39, he's already handcuffed. There are 4 times after that that Mr. Ellis said that he couldn't breathe. 4 times. So was that auditory exclusion? That they didn't hear it when they already had him handcuffed and they already had him on the ground? And don't forget the testimony of Jack Ryan about auditory exclusion. What did he tell you about it? He said auditory exclusion, what happens is that you're solely focused on the suspect, on what he says or she says. And that's what you hear. And what you don't hear is all the other stuff that's kind of going on around. So if it's auditory exclusion, you're not going to hear Shad Hayes, but you're going to hear the person that you're actually dealing with. That's what auditory exclusion is. And yet the defense tries to turn it on its head here and say, oh no, that means that I can hear everybody else, but I can't hear the most important thing. The guy that I'm literally sitting on. The guy that I'm literally pinning to the ground, that I've put handcuffs on. I cannot hear him say a single time, I can't breathe. Even though people 100 feet away can hear it, and even though we can hear it on the audio, and even though it's picked up on a camera more than 100 feet from where they are. That's not auditory exclusion. That's just not credible. So don't forget that this is one of the instructions that the court gave you. And the reason I raised some of those as just examples of things that the defense has said that aren't true is that this instruction specifically tells you that the evidence is the testimony and the exhibits. It's not. The lawyer's remarks, statements, and arguments are only intended to help you. But it goes on and says that you must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. And that's very important. So again, you guys get to decide the facts. You all have been paying close attention. You've listened very carefully. I know you have notes. You need to talk among yourselves about what you determine the facts to be and not accept what the defense is saying the facts are. And what about the instructions? These instructions that everyone has a packet of are really important, as the judge told you. This is what guides what the law is. And they're all written out, and they explain exactly what the law says. And those are the instructions. Again, you don't accept defense counsel's interpretation of what the instructions say. This is instruction number 23, which is the instruction on accomplice liability. And there was some discussion about it. And it goes through and talks about who can be an accomplice or what kind of conduct makes you an accomplice. And you'll see that the last line says, the last sentence says, this court has determined, and you must accept as truth, that neither defendant Timothy Eugene Rankin nor any other non-defendant officer on the scene was an accomplice. That's the limitation to the instruction. That's it. And what about this instruction? With respect to whether or not it's excusable. Again, you can read the instruction. Defense counsel stood up here and said that the state has to prove that the officers weren't acting, they acted without lawful intent. But you can read the instruction and see what it says. It says or, that homicide is excusable when committed by accident or misfortune in doing any lawful act by lawful means without criminal negligence or without any unlawful intent.
I think she just quoted the instruction.
Because there's an or, she doesn't have to prove that.
She has to prove the whole thing.
I also want to just take a minute and talk about this instruction, which was, defense counsel got up here and said, well, the state didn't say anything about murder in the second degree, or excuse me, manslaughter in the second degree, so they must not believe that there's any sort of criminal negligence. And that is simply not true. What you heard is that manslaughter the second degree is a lesser included of manslaughter in the first degree. And it tells you that in this situation, a person's criminally negligent or acts with criminal negligence when he fails to be aware of a substantial risk that death may occur and the failure constitutes a gross deviation from the standard of care. So by proving manslaughter in the first degree, which is what the state already talked to you about and walked through all of the evidence that proves that, you necessarily have proved that that they also committed manslaughter in the second degree. So the suggestion that somehow we didn't talk about it because it meant that we didn't have evidence of it is just simply not true. It's already subsumed within it. What about some of the other defense arguments? I want to talk about Dr. Clark and some of what the defense said. First of all, remember that in opening statements, defense counsel for defendant Rankin got up and said that Dr. Clark had determined that Mr. Ellis died of a meth overdose. And you quickly learned that that was not true, that he had never said that, and in fact he had always concluded that Mr. Ellis died from hypoxia due to the physical restraint. And then they said to you, well, Dr. Clark is the linchpin for all other experts in the state's case. They all relied on Dr. Clark's conclusion. But Dr. Clark didn't have the medical records. That's what they told you in closing argument, that he never had the medical records. But look at what Dr. Clark says. He was asked, and with respect to Mr. Ellis's death, what other information did you have besides your actual autopsy examination of him? And he said, I had the scene investigation that my office did. I had access to his medical records. I had a police report. So he did have access to the medical records. And then he was asked more questions about it. And he said, I did. I'm not sure if it came in with medical records or if it came in as part of the police report from South Sound 911. But I did have that. And then he was asked, you had it before you reached your opinions on May 11th. And he responds, I did. So Dr. Clark knew everything about Mr. Ellis's medical condition before he concluded that he had died from hypoxia due to physical restraint. That wasn't information that was lacking, and it wasn't lacking for all of the other experts. He knew all about Mr. Ellis's underlying health issues. And he talked about how he had access to the EPIC records, and he went through them. He even had records from Pierce County Alliance. Despite that, Dr. Clark concluded, you heard him testify, and you saw that he's a very careful individual. He walked you through all of his analysis in this case and how he got to the conclusion that Mr. Ellis died from hypoxia due to physical restraint. And he made a lot of sense about it. Now, the defense attacks Dr. Clark also and says, well, he and the other state's experts said that he had PEA, and there was no evidence that he had PEA, and that there was a normal sinus rhythm, on the life pack, and that's not true. But look at Exhibit 24. This is the pre-hospital report. This was written the day that Mr. Ellis died by paramedic Wilson. And what did paramedic Wilson put in this document? I mean, did the state's experts just make up that there was PEA and a sinus rhythm? This report, and it contains the strips, by the way, from the life pack, he wrote in there that it was rapid patient assessment with the BVM OPA airway management, monitor pads, ECG ×4, sinus rhythm deteriorating into bradycardia and asystole PEA. These were the observations that were made that day by Lieutenant Wilson. That's where PEA came from. That's where sinus rhythm came from. And those were the observations that he made. Now, the defense wants to say, oh, you can believe him on some things, but you can't believe him on others. But clearly, it's something that he saw, and it's something that Dr. Clark, as well as other experts, relied on, and it was confirmed by the life pack strips.
I'm going to object. That's the state's evidence.
Now,
The jurors are the arbiters of the facts.
what else is important about this? So what's important about it is that it absolutely describes what the state experts told you about what happened to Mr. Ellis, about the fact that he stopped breathing first and then his heart stopped. And that's what the life pack shows too. Mr. Ellis had a rhythm that should have sustained life. And the reason it didn't sustain life is because he had just been too far gone in terms of not having oxygen for too long of a period of time. And keep in mind, I mean, he said 8 minutes, 8.5 minutes before fire got there, more than that, about 10 minutes almost before fire got there, he had been repeatedly saying that he couldn't breathe. That's a long time to be able to be without sufficient oxygen. And that's what the cardiologist saw when he examined the strips. And that's what the two forensic pathologists, Dr. Clark and Dr. Mitchell, said, that all of those things are consistent with Mr. Ellis dying from hypoxia. He died from a starvation of oxygen. Exactly what he said that night repeatedly to these defendants. And you also heard from Dr. Wergelertner. Defense says, you know, oh, well, he didn't have the strips. He looks at those all day, and he looks at the life pack information. And what did he tell you? He looked at it. He has more expertise in the life pack and rhythm strips than any other witness in this case. And he told you that in looking at them, they support exactly what he had concluded already, which is that Mr. Ellis died from hypoxia. That's why you see that kind of rhythm. What else did the defense say about Dr. Clark? Well, they said that he had basically concluded that Mr. Ellis died from, or he called this case a homicide and asphyxia, because he was doing that because of some public perception that we needed to not cover this up. But is that really what he said? What he actually said was, here was the question, last bullet point you indicate, and this is from Collins's lawyer, for presentation to the prosecuting attorney's office, quote, further, there is some value to the homicide classification towards reducing the public perception that a cover-up is being perpetrated by the death investigation agency, right? And you remember, he was asked questions about that PowerPoint. You also keep in mind that when they were asking those questions, they weren't asking about all of the information that was on there. There were bullet points that they didn't ask about that definitely changed the context of what he was saying. First of all, Dr. Clark said that wasn't his opinion. He was putting that in because it came from NAME, the National Association of Medical Examiners. And then what does he say? He says that the reason it was there is because I thought it was relevant to the question at hand. It does not mean that I agree with these 3 bullet points necessarily. In fact, number 3, calling a case a homicide to reduce public perception, I think, is offensive. And you remember, he was very passionate about this when he said it. I would never have done that, and I don't think anybody should. I don't think it should even be in the position paper, but yet it is. Dr. Clark doesn't have an agenda in this case, and the suggestion that he does is frankly offensive. And you saw him testify. He's very careful. In his autopsy report, he was very clear that there were a number of issues. Now, that he saw, and he was very honest about it. In fact, he was the person, as he testified, who said, hey, you should go get another opinion. You should have this reviewed by somebody else, just to make sure to check my work. That's what kind of a physician he is. And that's what his report said, long before any of these other issues came up. In May of 2020, he determined that it was hypoxia due to physical restraint, and he called it a homicide. Keep in mind, as he testified, he did not even know at this point, because law enforcement didn't tell him, that Defendant Rankin had been on his back. He didn't know that. He reached this conclusion. So when they cite the different language in his report, and you'll see it, it's one of the exhibits that you have, he didn't know that there was an officer on his back. So he didn't comment about that. And yet he concluded that Mr. Ellis didn't die from a meth overdose, and he didn't die from heart issues. He died as a result of the asphyxiation from the hypoxia. I talked about this instruction in opening closing, and I just want to remind you about it, that there can be more than one proximate cause to a death. And that's important because there are other issues, and there always are. But remember that part of the reason why the law says something like this is that you can't kind of untether people's underlying issues. And the police know that as well, right? You go into a situation with somebody, and if they have an underlying issue, let's say you cause their death and they have a bleeding disorder and they die faster because they bleed without it clotting, that doesn't mean that you're not guilty of committing the crime. It just means that there can, of course, be more than one proximate cause. And so here, what the defense, in order for you to find the defendants weren't the proximate cause, you'd have to conclude that the restraint by the officers had absolutely nothing to do, and the assault by the officers and the detention of Mr. Ellis had absolutely nothing to do.
That's error, that's wrong. That's intentional and incorrect.
Well, Ms. Zeke's position presupposes an assault took place, and therefore there was unlawful force. The jury's been advised that if there was lawful force implied, an assault has not occurred, even if there's contact. Continue.
If you conclude that they did not act lawfully and that they were the cause, and with respect to the cause of death, but that's what you have to find. You have to find that their actions were one of the proximate causes of his death, not the only or sole proximate cause of his death. That's not what the law requires, and the instructions tell you that. What else did they say about Dr. Clark? Because they spent most of their time talking about cause of death in this case, as you know. They were saying that Dr. Clark said that this was super complicated. He's not sure of his conclusion. He wasn't sure that he actually died from that. But what did Dr. Clark say? He said, and this was all part of his PowerPoint too, because almost any forensic pathologist working through this matrix of information would come to the same conclusion that I did, that methamphetamine is unlikely because there was no ventricular fibrillation, that sudden death from his enlarged heart is unlikely because there was no ventricular fibrillation, and that leaves hypoxia, and that was caused by restraint. And again, he encouraged the state to get another opinion, and Dr. Mitchell did that, an independent opinion from Dr. Mitchell, and he reached the same conclusion. Again, he was careful, he was methodical, and his conclusion has not been rebutted. I want to talk for a minute about what else the defense claimed, this argument that if there had been a breathing issue when they put the bag valve mask on Mr. Ellis, that he would have come back and he would have been okay. And so that proves it was a heart issue and not any sort of a lung issue. But remember what Dr. Stankus even said about it. She was asked, I want to go back to your testimony regarding BVM. Would you agree that at a certain point, a patient or a person is so far gone that a BVM wouldn't make a difference? And she said, sure. For instance, someone who is brain dead, sure, yes. Now, she's not the only person who testified about this. You'll recall Dr. Wergelertner. I mean, the idea that the BVM wasn't successful and that somehow that indicates that this was a heart issue as opposed to a breathing issue is just false. I mean, remember Dr. Wergelertner gave an example of a campfire, and he talked about the fact that if you suffocate a campfire by not giving it enough oxygen, at a certain point, it's like so far gone, the embers are so far gone that nothing you do can kind of bring it back. And that's essentially the same thing that happened here. At the point when fire got there, Mr. Ellis was beyond being able to be saved. It had been too long that he didn't have oxygen. And it didn't matter how much they used the BVM and tried to pump oxygen into him. It wasn't going to change things. All right, so I just want to talk for a minute about the defense arguments with respect to the three independent witnesses. So the defense argues that you should disregard the testimony of Sarah and Seth and Keon. And they say a number of things about it. They say, first of all, they should have come forward sooner. You can't believe them since they didn't come forward right away. Then they say, well, maybe they were paid off by James Bible, which is not only offensive, but also slander. And that Seth and Sarah, or another option is maybe Seth and Sarah collaborated about what they were saying, and that's how they got their stories together. And fourth, that Sarah had always planned to lie, and she admitted she was going to lie in a direct message to a person who was supporting the defendants. So I just want to talk about each one of those for just a minute. The idea that they should have come forward sooner. Now, you can remember back to what Ms. McDowell said when she was asked about her timing in terms of coming forward. And what did she say? She was asked, and she said June 3rd, or I think it was June 3rd. Maybe it was June 4th. It was, I believe, on Facebook. I came across a news article, and I was reading it. It was about a guy that was in the intersection trying to get into people's cars, maybe even houses. I can't remember. Who was attacking an officer or their patrol car, whatever. I mean, I didn't think anything. I was just like, whatever. But then once I got to the address and the time and the date, I was like, wait a second. And so I hurried up and went to my phone camera and to the video timestamp. It matched the same exact time that they were like stating in the article, the same day, same street, and so I panicked. I messaged Jesse, her fiance, asked him what he thought, like, what do I do? Because I didn't want to send it to the police because I was scared. I was like, the police did this. So is it a reason to doubt Miss McDowell that she didn't come forward sooner? She had no idea that Mr. Ellis had died. Remember, that's what she said. And why would she? When she left, he was alive on the ground and he was being handcuffed by the officers. She didn't know that anything had happened. It wasn't until Dr. Clark determined that it was a homicide and it became public that suddenly she saw these news articles. And why did she come forward to the family lawyer? For exactly the reason that she said. She's reading something that is false, that she sees in the paper about what purportedly happened, that's different than what she saw, and she's afraid to bring it forward to the police. What about Seth Cowden? He too was asked about why he didn't come forward sooner. And he testified that the video was on his phone for a while. After about a month or two, I didn't see any reason to bring it up until I saw a newspaper with Manuel Ellis and the street names of South Ainsworth and South 96th Street on the front of the paper that I saw. I saw that at a gas station. It looked familiar to me. When I realized that that was the street where I saw someone, having an interaction with the cops or whatnot, I decided to read the article and look into it more. I did not know that Manuel Ellis died until I saw the newspaper. That's what he said. So again, did he delay coming forward and that's a reason to doubt what he has to say? Or did he too, as he said, and you can see in the video, when he drove away, Mr. Ellis was alive. And there was no information about his death that they saw until early June of 2020. Oops. Sorry, different clicker. I also want to talk about the claim that the defense made that somehow their phones were mysteriously went missing after they saw Mr. Bible. And again, the instructions tell you that you have to disregard things that aren't actual evidence, and you can disregard claims that are just sheer speculation. There's no evidence that Mr. Bible or anybody else somehow tried to destroy the phones in this case, or that Miss McDowell did. And you remember this exhibit, which I can't read the exhibit number on it, but it's one of your exhibits, 894. And you recall that there was testimony about this because Miss McDowell, the day after she initially came forward, she was emailing or she was texting with Monet, and she was asked about, she hadn't been responding. And she says, yeah, hey, yes, my phone broke. I'm going to get a new one in a little bit. Overslept. I mean, is that somebody who intentionally destroyed the phone and that it was intentionally destroyed at the behest of the family lawyer, Mr. Bible? There's just absolutely no evidence of that. And Mr. Cowden didn't say that his phone was destroyed. He said that his phone died at some point and he didn't have it. And he didn't have the video on his phone anyway, he testified, because he took that video in Snapchat and he posted it to another friend. So it wasn't actually on his phone, even if he had his phone. So again, remember and go back through your notes exactly what the witnesses said about it, as opposed to the conspiracy theory that the defense is offering here. And what about the claim that they made with respect to Miss McDowell, that she somehow is just out to get their clients? And ask yourself, first of all, what interest does Miss McDowell have in coming in here and saying something that's not true about these officers? I mean, is there any doubt that she was there? She has a video showing that she was there. She's said that from the very beginning. She's made consistent statements from the time that she first came forward about what she'd seen. But the defense puts up this message and says, well, she's coming in to lie about it. And what did she say about why she wrote that message? She said, the whole thing has made me so emotional, and I was hurt and I was upset of the whole thing that had happened. I was hurt and angry about the people that were saying things or twisting up, not twist, just changing, and like saying that I was lying or saying that I had seen didn't happen. And I was hurt. So I commented back to quite a few people that they were against me and against what I had seen. That's what she said about this message that she wrote. And the defense says, this is proof that she said that she was going to get up and lie. Well, is that really what she's saying? I mean, ask yourself, does that make any sense? She told you that it was a typo or an autocorrect issue, that she said that she was dying. And look at what it says. Does it make any sense otherwise? None of you people will ever have anything on my story. Wait till I'm in the stands. I'm lying to shut you all down. What kind of a statement is that anyway? Just wait on it. Doesn't it make more sense if it's exactly what she said? Wait till I'm in the stands. I'm dying to shut you all down. That's what she wrote. And besides, ask yourself, is it consistent with the idea that she had somehow been in cahoots with Mr. Bible and that she was making all of this up and that she's just out to get the officers? I mean, if she had done that, and that's what she's doing, would she be so stupid as to write a text like this, a message like this, to somebody that she knows and they established is a supporter of the defendants? I mean, it just doesn't make any sense. She's not going to do that. Obviously, she was 22 years old. She's young. She's upset. It was the worst thing she'd ever seen happen, she told you. And she did write to people. And she felt very strongly about it because it's changed her life significantly. And she talked about that too. I mean, this is somebody who did not ask to be part of this case. Just unfortunately for her, she was driving that night on 96th, and she happened upon it. You saw these instructions, and I'm not going to spend much time on them now because you've heard the testimony about what is required to be proved. And it has to be necessary, is the requirement. Instruction number 25 says it's not necessary. Well, let me back up. You heard from defendants Burbank and Collins that intervening causes them to relieve them of liability in the case. And they said that they walked away and that they had no other responsibility or interaction with Mr. Ellis after he was tied up in the hobbles that were connected to the handcuffs. So their argument is that it's not, their actions aren't a proximate cause because they walked away and they didn't have anything to do with it, so they shouldn't be responsible. But you have an instruction about this, which is instruction number 25. And it talks about when a defendant has set in motion forces that lead to a death, what types of things that happen after that that break the chain of causation. So the defendant isn't responsible for what happened. That's what this instruction goes to. And importantly, what it says is that it's not necessary that the sequence of events or the particular injury be foreseeable. It's only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. And that's exactly what we have here, the general field of danger. They knew that Mr. Ellis had said that he couldn't breathe, repeatedly. And they tied him up with the hobble, they connected it to the handcuffs, they kept him in a prone position, and then they say they walked away and that they're not responsible. It was entirely foreseeable. They were trained in exactly this. They understood exactly what the risk was, that he could die. Now, defense says, well, there's no such thing as positional asphyxiation, and it's debatable. Why are the officers being trained in it? For decades, they've known that this is a risk. And your common sense tells you that, of course, it's a risk because you've seen it. There's also talk about what the requirement is with respect to necessary. And again, it does say that you can use all force that's necessary to effect the arrest, but it's modified by this instruction, which tells you what necessary is. That it requires, under the circumstances that they appeared at the time, no reasonably effective alternative to the use of force appeared to exist, and the amount of force used was reasonable to effect the lawful purpose intended. Now, you heard testimony about this through Jack Ryan and about what the reasonable alternatives would be. But I would just say, as you consider this issue, what the defense really never talks about is the period of time after Mr. Ellis was fully restrained. And he stopped moving and he stopped fighting. Minutes, 5, 6, 7 minutes, that Mr. Ellis wasn't doing anything. And during that period of time,
Again, there's a dispute of fact about this.
during that period of time, what reason could there have been to use force on Mr. Ellis for any purpose? And I'd suggest to you that the evidence has shown that there wasn't any reason to use any sort of force. And there were reasonable alternatives. Mr. Ellis could have been released from the hobble, plenty of officers there to take care of him, to make sure that it was still secure. He could have been sat up, he could have been stood up, he could have been put in a patrol car. There were just so many options to not use force on him because he wasn't fighting that entire time. He wasn't actually moving, he wasn't responding. That's the testimony that you heard from Messiah Ford. And you heard that in the defendant's statement, Defendant Rankin's statement, that he wasn't doing anything. And so there was reasonable alternatives, and there was no reason to continue to use force against him. Just a couple more things. I know we're getting close to the end of the day. The defense says that Mr. Ellis was psychotic and that he was unpredictable and he was violent that night. That's the Manny Ellis that the officers encountered that night. And that he was particularly impacted by that because they claimed that he was clean and he hadn't used any drugs. And they cite to the 2015 and 2019 events and say, hey, these are the reasons why. You can see how he behaved that night. And I would just ask you again to use your common sense. And what is the best evidence of how Mr. Ellis was that night? And the Mr. Ellis that these defendants encountered. Isn't it the best judge of his conduct is what you know about how he was that night? You know that he went to church, that he had a video call with his mom, that he helped Cedric Armstrong with his Wi-Fi issues at the house, that he ate dinner, that he walked to the 7-Eleven. He purchased 2 items, a gallon of water and a box of donuts. Nothing about that suggests that he was in a meth psychosis. He used his EBT card to make that purchase. Nothing.
There was evidence, there's discussion of the EBT card, if that's what you mean. So, it's a factual issue for the jury.
The evidence was that he used his EBT card to make that purchase of the donuts and the water, and that he had it on his person at the time that he was killed. Again, there's nothing about those actions that say that he was in a meth psychosis and that he was somehow out of control. Then you know that he's at 96th and Ainsworth, and you've got 3 eyewitnesses, 3 people who have absolutely nothing to gain by being in this case, have absolutely no stake in it. And what do they see? He's on the sidewalk, walking. Nothing unusual about what he's doing. Again, no evidence that he's psychotic or that he's out of control or that he's violent or that he's in a meth psychosis. And then they see him be apparently summoned over to the police car. And you see him get up, or they see him walk over towards the police car, again, responding to whatever is being said to him that calls him over to the police car. There's nothing psychotic about that. There's nothing that shows that he's violent or that he's out of control. Then, after that, you have not only what the witnesses see, but you also have the video and you have the audio. And what you see on the video, you can judge yourself, is not a person that is out of control in a meth psychosis, who's attacking the officers, who's attempting to kill the officers, who's coming at them with the fight of their lives, as they said. And then you hear him. So unusual in a case like this that you would actually be able to hear the murder victim. But you can hear him on the audio. And what's he saying? He's not threatening the officers. He's not incoherent. The words he uses are all words that anyone can understand. Please, I can't breathe. I still can't breathe. Sir, please, I can't breathe. Isn't that the best judge of what his behavior was that night? He wasn't out of control. He wasn't in some sort of a psychosis. Oops. All right, I want to talk just for, again, a second about what they said about Ayanna White, or Ayanna Malang. The defense says, well, she's the silver bullet. She says, and she confirms that there was some sort of an altercation going on before Sarah McDowell actually arrived. Now, you remember they counted out the number of seconds that she said she was waiting. Well, remember what Sarah McDowell said. Sarah McDowell said that she was describing what happened. Then Manny, he turned around to me, what looked like he was walking away, going towards the sidewalk again. But before he could get to the sidewalk or walk away, the passenger door swung his door open and knocked Manuel to the ground, to the floor, or to the ground. He was on his knees, and then he jumped out. And then she says the driver officer clicked on his yellow lights, jumped out, ran around the front of the cop car. That's what Ms. McDowell testified about. She was very specific. The Ambers were not on the car when she first walked up there. And we see in the Vivint video that they're on at that point. But when she got there, they weren't on. So did something happen that Ms. Malang saw, as the defense wants you to believe? Well, look at what she says about what alerted her. This, again, is on cross-examination. Fair enough, but when it caught your attention, it was both the noise and the police lights. Is that right? So when Ms. Malang first becomes aware that something's happening out on the street, it's the police lights that draw her attention. She didn't start seeing what happened until after Sarah McDowell was there. Just a couple of final points. The defense has talked about the fact that there's all these other agencies that were present and that they didn't intervene. And that must mean that nobody saw that anything was going wrong, and that there was no improper action by the officers. Well, keep in mind that there's no evidence that any of those officers knew that Mr. Ellis had been beaten, choked, and tased. They didn't know that he had been stopped without any cause, and that there were eyewitnesses who had seen what happened, and that there was video that showed what the officers did.
All facts, not evidence. It's not true.
We don't have any testimony from the officers about what they knew.
I'll move on. What the officers did say is that, or at least what Defendant Collins and Defendant Rankin said, is that they didn't tell anybody that Mr. Ellis had said he couldn't breathe. And that's most important. They knew that he said he couldn't breathe, and they didn't tell anybody. And that's a critically important fact, because if that is the fact at which somebody would understand that there was a risk here.
There's no evidence that my client said he knew that this was said and didn't tell somebody that. That's just not true.
Well, it's certainly disputed by the parties, and the state claims it's a reasonable inference to believe that he knew.
That's right. Again, as I said in closing argument, you have to decide whether or not Officer Collins' claim that he didn't know and he didn't hear Mr. Ellis say, "I can't breathe," is credible. From the state's perspective, looking at that evidence, it's not. You heard it yourself. You heard the witnesses, including Officer Ford and Officer Rankin, about the fact that everybody was there when Mr. Ellis made those statements. But there's no evidence that that information was ever passed along. My final point. You heard criticism of the state about not calling additional witnesses beyond the 23 witnesses that the state called over 6 weeks. And that the only thing the state had proved, only thing that the state needs to prove are what's in these instructions. And the elements that are required in here. In instructions 34, 35, 37, 38, and 39 are what are called the to convict instructions. Those are the elements that the state has to prove. And that's it in order to make its case. So let's talk about,
The state So has to prove the absence of the lawful use of force and the absence of excusable homicide
That's correct.
or manslaughter.
So let's talk about the evidence that you heard on the second-degree murder case and turn to that interaction. The state called 3 eyewitnesses who saw the event and how it started, and they told you what they saw happen. We also called a reconstruction expert so you could see where those eyewitnesses were at the time and understand what they were able to see and how they were able to see it. We called a 4th eyewitness, which is Miss Malang, who started out watching it even after it was underway. And she too heard Mr. Ellis say that he couldn't breathe, and she, like the other eyewitnesses, said that she never saw any sort of assaultive conduct by the officers. The state also showed you all of the various evidence that there is, the objective evidence about what happened that night, the video evidence. You heard the dispatch. You heard the audio from the videos. You had all of that evidence in front of you. We called investigators, Investigator Aztet, Stephen Mell, and Mr. Wilkins. State called Investigator Brockway, who took the statements from the defendants. And we played their entire statements for you so that you could hear what their version was. And you could determine, compared to what the eyewitnesses said, whether or not it was credible. On manslaughter charge, again, the state has to prove that the conduct was reckless and that it was, and you've gone over what that means, that it was a substantial risk, that they understood there was a substantial risk of death, and that they disregarded it, and it was a gross deviation from what a reasonable person would do. And so the state called a police practices expert to tell you about reasonable police practices. And the state played the audio for you of Mr. Ellis saying multiple times in the presence of each of the officers that he couldn't breathe. And they had knowledge of that based on the evidence that you've heard in the case. His own words telling you that he said he couldn't breathe. And again, the state played the statements of the officers themselves. So the state put on all of that and also put on another investigator about the hobble, put on a DNA technician about the fact that there was the DNA on the case, on the hobble, called the firefighter about the evidence that he saw and the condition that Mr. Ellis was in when he got there. And then finally, the state called 4 experts, medical experts, to explain to you how Mr. Ellis died. You had all of the information that you need to have in this case. You have everything that you need in order to evaluate the facts. Is there really anything else? The defense says, well, they didn't call the people that we called. Again, the defense doesn't have any obligation to call people, but they did. But did it really add anything? Shad Hayes said exactly what the other eyewitnesses had said. He never saw any assaultive conduct by Mr. Ellis. And what about Kenneth White? He too said he never saw any assaultive conduct by Mr. Ellis. And in fact, he even added, which you already knew, that Mr. Ellis had said that I can't breathe. He heard him say, I can't breathe. And he heard it from the house over 100 feet away. And what about Officer Ford? What did he say that was different or new? He said exactly what the police practices expert said about what the training is and what they understand about the dangers of a prone positioning, about weight on the back, in the middle of someone's back, about the use of a hobble in a way that connects it to the handcuffs that restricts somebody's breathing. One fact that he did add was that the statement, and he told you exactly what you already knew from Officer Rankin's statement about what he did. That he'd been on his back, that he rolled him briefly to recovery, that he got back on his back, that he was putting pressure on him. And he said that they knew, they heard Mr. Ellis say that he couldn't breathe. And he confirmed that Mr. Ellis, or that Officer Rankin had said, if you're talking to me, you can breathe just fine. One thing that Officer Ford added was that statement was made sarcastically. So I'd suggest to you that the state has proved its case, and the state gave you all of the information that you needed to meet the elements of what's required. There's no need to call cumulative other witnesses that may or may not have added anything to it. You have what you want and what you need, and the instructions tell you that you need to decide the case based on the evidence that's been presented. It's really the evidence in this case that matters, not speculation, not arguments, not suggestions by the defense about what they think that the facts are. And you all need to work together now as jurors and listen to each other and consider what you conclude the facts actually are. That's your task in this case. And the state submits that when you do that, that you'll find that there's sufficient evidence to find the defendants guilty as charged. You know, Mr. Ellis was a human being, and he deserved the dignity that anyone deserves. Doesn't deserve to be put on trial in this case, and he didn't deserve to have the basic thing that he was asking for from these officers. To please just let him breathe. To have that be ignored repeatedly and to do nothing to help him after he has said that over and over and over again is reckless conduct. There's no question that it's reckless. Certainly it's criminally negligent. Mr. Ellis didn't need to die that day. If only he had been granted the dignity of being human and being responded to.
Are you done, Mr.
I'm done.
Okay. All right. Jurors 15 and 16 are alternate jurors. As alternate jurors, you're selected to serve in case one of the other jurors becomes unable to serve on the jury. I want you to pay attention with what I'm about to tell you, gentlemen. I'm now able to temporarily excuse you from further service in this case. Note the word temporary. You're not fully released from this case. You could be recalled for further service if one of the deliberating jurors becomes unable to serve. Accordingly, my previous instructions regarding your activities outside the courtroom still apply to you, and they will continue to apply to you until the full jury has completed its deliberations and been discharged from the case. To summarize these obligations, you are not to discuss the case or how you would have voted regarding this case, nor are you to investigate the law or the facts of the case in any way. Do not permit anyone to comment on this trial to you or in your presence. It is important that you keep your mind free of outside influences in the same manner as if you remained one of the jurors in this case. And so accordingly, also refrain from any news accounts in the media or otherwise on the subject of this trial. If you are needed further in this case, you will be contacted. Mrs. Winnie will give you a couple certificates of appreciation by me for your service so far. You'll also have her business card there, and if you can contact her if you want to know anything about the status of things. But when there is a resolution of it, or if we need you back, Mrs. Winnie will contact you and let you know that. Meanwhile, she'll keep your notes and your jury instruction packet for you to return for you should you come back to serve in our case. In the event that you're not needed any further, I want to thank you, and as I say, a certificate of appreciation. It's important as an alternative juror that we have you present for this. We're going to have a fair and efficient trial. And as you already know, that we've already lost a couple of folks already in this case, and so it's entirely possible we could lose someone before. This is not a hypothetical thing whatsoever. We've sometimes called other folks back. And then when we do that, we ask the jury to start their deliberations from the beginning with the new person involved. But with that, I'll let you go with Mrs. Winnie now. Take your notes and your jury instructions with you. And I'll let you, if you guys could stand and let those two jurors slip out. The rest of you stay around for just a moment longer. And Mrs. Winnie will come through over here and she'll let you, and she'll get that stuff from you. Thank you both, John, very much. Thank you. Okay, the rest of you can be seated. For the rest of you, as you know, we've got various pieces of paper and stuff for you that you can write on back there. You've got your set of the jury instructions. The original set of the jury instructions will come back to you along with the exhibits. Now, before the exhibits can come back to you, we've got to have a session with the lawyers to make sure that we properly segregate all these instructions, or all these exhibits rather, from the ones that we've simply marked to the ones that we've actually admitted. And it's going to take a while, as you might imagine, because we have a lot of exhibits in this case, for them to sort that through that and satisfy themselves that these exhibits have been properly segregated from the ones that are supposed to go back to the ones that are supposed to stay here. So we're at 4:15 now, so you're not going to be able to start your deliberations today. So we're going to do that tomorrow. It's going to take us a while to get through all that. And then either Mrs. Winnie or Mr. Mattson, you may remember Brian Mattson was here briefly. I expect him to be here tomorrow morning. And they'll bring the exhibits back to you, as I say, along with the original set of the instructions. And they'll say you can start your deliberations. So until then, even though you're all together there, back there, please do not discuss this case among yourselves. And, but we're close. And you have your instructions about returning tomorrow. Keep those in mind. And we'll see you then. So we'll let you go here. But actually, I'm not going to let you go for just a minute. Because I want to make sure Mrs. Winnie's actually completed with the other two jurors and she comes back into the room for us. As I said, you can write on just about anything back there. And as I say, if you need something else like additional pads of paper or one of those easels or something, let Mrs. Winnie know. You can write on about anything except the walls. The maintenance people kind of get worked up if you do that. So don't do that. But so with that, just give us a moment or two for Mrs. Winnie to rejoin us, and then we'll let you go. And as I say, at this point in time, you can take your copy set of the jury instructions and your notebooks with you back to the jury deliberation room.